Good evening, everyone.
Good evening, sir.
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 Only join those who are having internship this month. For January month, we will be having session in January. So today is first class, and I may be attending classes this month only, and also I have to complete whatever I'm going to teach you. So there are the variety of students from different semesters. So I have planned to teach about PIL instead of going through civil or criminal or any other corporate field. It is best to teach PIL because most of the students, those who wish to work for the welfare of the society, they must know they have the power to file PIL even as a law student. So once you become a lawyer, at that time you would be able to file civil petition or criminal petition. But this time, as a law student, the judicial power you have presently is to file PIL. So it is best to teach about PIL, how you can file it, and how you can get the exact remedy through the courts. So before we start with the draftings, we'll go through the basics about the PIL, what exactly PIL is. And then if tomorrow, today, or in the next class, we'll start with the PIL drafting. But before that, because whenever we have to draft something, we have to know certain things, that what exactly issue is and how we will get the materials for drafting. You must be having backgrounds about the content, then only you can generate content while drafting. Any of the issue you take for the drafting, you need to learn about it, you need to have research about it, then only you would be able to draft it. Otherwise, there will be nothing to write in the drafting. So, is the student leader there?
Yes, sir.
Yes, sir.
Aditi and Manya. Okay. Any other student was there as a student leader?
There's one
So,
more student.
yeah. So, Aditi, you need to note down the name of students, those who are the attendees,
Okay, sir.
and also you have to prepare an Excel sheet where you can mention the name of students, those who are attending today's class, and then once they will be assigned assignments, whether they will be submitting back or not. So, as per the track records, you have to maintain that file. Okay. In the
Okay, sir.
last of this internship, I will be going through the Excel sheet about the student records, how many classes they have joined, whether they have submitted assignments on the portal, through the mail, whatever we asked to submit or not. So these things will be checked, attendance will be checked. So you need to mark down. So shall we start? You need to note down few things in case. However, I'm not going to uh, create any Q&R session. I'm just going to teach you basics because I'm not emphasizing on theoretical parts while this is the practical class aspects. So I will be talking about practical aspects only. But you must know about PIL, what exactly it is, how and what powers they bear. So any of you know PIL full form? Tell me.
Public interest litigation.
Public interest
Public interest.
litigation.
Yes.
So it's a public interest litigation.
Good. So we are talking about public interest litigation. So the public interest litigation has been borrowed from American jurisprudence. Okay, it's not an Indian; it's an American. So it was borrowed from American jurisprudence, where it was designed to provide legal representation. Okay, how, to whom? Those previously unrepresented groups like poor, racial minorities, unrecognized consumers, citizens, and who are passionate about the environmental issues. So, for those categories, for their representation before the before the court, PIL was introduced. Understood? Now, if we talk about PIL means litigation filed in a court of law for the protection of public interest, such as pollution, terrorism, road safety. And then, if we talk about the constructional hazards, or any other matter where the public interest or the public interest at large is affected. So that can be addressed by filing a PIL before court of law. So the public interest litigation is not defined in any statute or any act. Nowhere in the constitution, nowhere in the acts, nowhere in the statutory acts. You can find this PIL is nowhere defined. But it has been interpreted by the judges to consider the intent of public at large. Okay. So it's also the only judges can interpret it according to the matter of the fact. Public interest litigation is the power given to the public by courts through judicial activism. However, the person filing the petition must prove to the satisfaction of the court that the PIL is being filed for a public interest and not just as a frivolous litigation by a busy body. So these things has to be ascertained by the court, because court has given this power to the public for the interest of the minorities, of those who are the poor section, those who are the in danger, or the matter is concerned about public at large. So these can be challenged by the through the PIL. The court can itself take cognizance of the matter and proceed suo motu, or cases can commence on the petition of any public spirited individual. So sometimes, if you know that the courts are there and some of the matter is already going on, and the large number of public are taking interest, so sometimes court also issues Shimoto. Court also take cognizance. Like recent example is one of the election was held, and in election one of the election officer was counting the votes, where he was damaging some vote counts, and it was recorded in the video and that was circulated on the internet, and on the basis of that Supreme Court directly issued suo motu and took cognizance of this matter. So similarly, multiple examples are there. Some matters which are entertained under PIL are bonded labor, neglected children, non-payment of minimum wage to the workers, exploitation of casual workers, atrocities on women, environmental pollution and disturbances of ecological balance, food adulteration, maintenance of heritage and culture. So these kind of matters has already been entertained through this PIL. Understood? Now, if we go through the history of this PIL, how this PIL was introduced, emerged, and who was the first person who had filed PIL. So, for that, if we go through its history, we find the seed concept of PIL was initially shown in India by Justice Krishna Layar in 1976 in Mumbai. And one of the matter was Mumbai Kamanagar Sabha versus Abdul Thai. In this matter, Justice Krishna Layar introduced PIL, means on the basis of public interest, the matter was entertained. And first reported case, if we talk about, is Husainara Khatun versus the state of Bihar, and that was also held in 1979. That focused on inhuman conditions of prisoners and under trial prisoners that led to the release of more than 40 prisoners under trial. Here, right to speedy justice emerged as the basic fundamental rights which has been denied to these prisoners at that time. And the same sad pattern was adopted in subsequent cases. Okay, so this is the power of PIL. Otherwise, nobody had a direct code in the constitution or any statutory act to go through a file on behalf of these peoples, where no such remedy arises through the acts. So the PIL is one of the tool which can be utilized for large number of people's interest arises. In new era, if we talk about PIL movement, so it was held by Justice P.N. Bhagwati in the case of S.P. Gupta versus Union of India. So in this case, it was held that any matter of the public or social action group, actionable or acting bona fide, can invoke the writ jurisdiction of the High Courts under Article 226 or Supreme Court under Article 30, 32, seeking redressal against violation of legal or constitutional rights of persons who, due to social or economic or any other disability, cannot approach the court. So I repeat, Justice P.N. Bhagwati in the case of S.P. Gupta versus Union of India, it was made clear that any member of the public or social action group acting bona fide can invoke the writ jurisdiction of high courts under Article 226 or Supreme Court before Supreme Court under Article 32, seeking redressal against violation of legal or constitutional rights of person who, due to social or economic or any other disability, cannot approach the court. So, by this judgment, PIL became a potent weapon for the enforcement of public duties, where executive action or misdeed resulted in public injury. As a result, any citizen of India or any consumer groups or any social action groups can now approach the apex court of the country seeking legal remedies in all cases where the interest of general public or a section of public are at stake. Again, if we talk about Justice Bhagwati, who did a lot to ensure that the concept of PIL was clearly enunciated. He did not insist on the observance of the procedural techniques or technicalities, and even treated ordinary letters from public minded individuals as writ petition. For example, if you think in your area large number of people are suffered from such issue, from a particular issue, and you thought to write about those issues because large number of public are affected, you write a simple letter to the apex court, to the chief justice, to the high court chief justice, and as in such case where Justice Bhagwati took this simple letter as writ petition, maybe your simple letter could be entertained as writ petition. As PIL is already introduced, so PIL is one of the tool. Similarly, various other matters like Supreme Court of India in one of the matter, that is Indian Banks Association Mumbai versus Devkala Consultancy Services. In this case, in an appropriate case, where the petitioner might have moved a court in her private interest and for redressal of the personal grievance, the court, in furtherance of public interest, may treat it as necessity to inquiry into the state of affairs of the subject of litigation in the interest of justice. So, there are various examples if we talk about. Similarly, one of the famous cases, uh, MC Mehta versus Union of India. In this case, the PIL brought against Ganga water pollution so as to prevent any further pollution of Ganga river. Supreme Court held that petitioner, although not a riparian owner, is entitled to move the court for the enforcement of statutory provisions, as he is the person interested in the protecting the lives of people who make us who make use of Ganga water. So Ganga is not owned by any particular person. Any simple person has filed a petition before Supreme Court and Supreme Court has entertained it. In another case, Vishakha versus the state of Rajasthan. In this case, one of the judgment is that the case recognized sexual harassment as a violation of fundamental constitutional rights of Article 14, Article 15, Article 21. And further, the guidelines also directed for the sexual harassment of women at workplace. In Vishakha versus the state of Rajasthan, it is because of the PIL. Okay, so these are the numbers of cases where PIL brought its recognition. And now, if we talk about the statutory provisions or the where what is the uh, uh, status in the constitution, then if we talk about constitution, that the character of Indian constitution, where India has a written constitution, which through part third, which is fundamental rights, and part four, directive principles of state policy. So these two has provided a framework for regulating relations between a state and its citizens and between citizens and interstate. As you know, India has some of the most progressive social legislations to be found anywhere in the world, where it is related to bonded labor, minimum wage, land ceiling, environmental protection, etc. This has made it easier for the court to haul up the executive when it is not performing its duties to ensure the rights of the poor as per the law of land. Any of you have any question in this? Nobody?
Does PIL come under the definition of a right?
Sorry?
Can PIL be considered a right?
Considered as writ?
Yeah.
Definitely. Let me tell you how and who can file and against whom. So any person who can file PIL, which is through Article 32. As you know, the Article 32 talks about writ in Indian Constitution. So if you wish to file PIL, you can file a writ under Article 32 of Indian Constitution if you are filing before Supreme Court. And if you are filing before High Court, then you have to file under Article 226. And also, if you are filing before the magistrate, Court of Magistrate, then you can go through the previous Criminal Procedure Code under Section 133. However, court must be satisfied that the writ petition fulfills some basic needs for the PIL as a letter is addressed by the aggrieved person. Okay, so any PIL filed, it must be addressed by the aggrieved person, public spirited individual, and social action group for the enforcement of legal or constitutional rights to any person who are not able to approach the court for redress. So these criteria should match. Otherwise, petition will be rejected. Now, PIL can be filed against a state or central government, municipal authorities, but not any private party. You have to remember that PIL cannot be filed against any private party. For example, there is a criminal. Uh, leave. There is a terrorist who terrorizes. Large number of people are affected in the state. Since large number of people are affected, can we file PIL? No. We can file PIL against a state, central government, municipal authorities. Is it clear? The definition of a state is given the same as given under Article 12 of the Constitution, and this includes the government and the Parliament of India and the government and the legislature of each state and all local and other authorities within the territory of India or under the control of government of India. So these are comes under the state. So you can file petition against a state. So coming back to its significance, what exactly the benefit of this PIL and what its aim is? Majorly, the aim of PIL is to give the common people access to the courts to obtain legal redress. PIL is also an important instrument of social change and for maintaining rules of law and accelerating the balance between law and justice. The original purpose of PIL have been to make justice accessible to the poor and the marginalized section. Okay, it is an important tool to make human rights reach those who have been denied their rights and so on. It helps in judicial monitoring of state institutions like prisoners, asylum, protective humans, homes. It is also a tool for implementing the concept of judicial review. So these are the benefits, these are the uh, significant benefit if you go through the PIL, if you start learning about it. Definitely, you will be getting some best thing out of this syllabus, out of this knowledge. Now, these were the introduction of the PIL. I'll give you 5 minutes. Within 5 minutes, you need to you can ask some question, and then we'll start with the drafting. Venika,
Yes, sir. Could you please repeat all of the benefits of a PIL?
sorry.
Could you please repeat all of the benefits of a PIL?
See, there are the various benefits as I told you. Firstly, it gives powers to the layman, general people. Through this PIL, if any single person want to go to High Court or Supreme Court, they can directly go through it by the constitutional article 226 for High Court and 32 for Supreme Court. That is the very first significant. Secondly, it also give power to social change. It is an important instrument of social change. It maintains rule of law and accelerate the balance between law and justice. And the original purpose of this PIL to make justice accessible to the poor and marginalized section, and also good for those seeking human rights, those who have been denied their rights. If their fundamental rights are violated, so this PIL can be filed. And also those who are the prisoners, asylum seekers, those who are in asylum, like if we talk presently in India, they are the Rohingyas, they are the some Tibetan, they are the asylum seekers. If their gender rights are violated, like human rights, if India doesn't treat well, if Indian citizen doesn't treat well with them, even though they are the migrants, even though they are the asylum seekers, still they have their own human rights. if the human rights are violated. On the basis of that, any Indian citizen can file PIL. It also a good tool to challenge judicial review. It also a good tool to implement the concept of judicial review. So these are the significant. Hope you understood.
Yes, sir. Thank you.
Yeah. Now, any other question? Okay, so let me ask you, any of you. Arjun is there?
Yes, sir.
Yes, Arjun. What do you understand by this PIL?
Uh, how- Basically, it's like a it's like a method given and an avenue of law given to everyone to
Mm-hmm.
contest to contest their issues if they are in the best interest of the public, which the law itself or the procedure cannot uh, exactly give justice to. I think I understand it that way, sir.
Yeah, somewhat correct. And okay, Ananya Jain, tell me, is there Ananya Jain? Okay, next, Akshat. Akshat is there.
Yes, sir. So PIL is a petition filed before a court to protect and safeguard the public interests, and like it covers various areas such as the environment, human rights, the governance, consumer protection, etc. Like it is a petition to it's to safeguard the public interests.
Good. Aditi.
Yes, so
Yeah, tell me any significance.
it is help for public good and anyone can file it because it doesn't affect only one person but for public, and it helps the voiceless people.
Good. Good. So these are the significance, and uh, now let me tell you, whenever we file PIL, I have recently filed PIL in last year. I had filed PIL on behalf of one of the political party, and that was related to CA. And also, uh, I'm about to file one more PIL on behalf of. I mean, we are about to challenge validity of constitutional law on some points where they are the two, the toughest statutory law, special law in Uttar Pradesh, Gangster Act, Gundas Act. So, because those large number of people are affected by those special laws, police are given huge power, and government uh, has its own will to implement and enforce this law anytime on any of the person. If they want to stabilize anything, or if they want to reduce anyone's power, they can generally impose such things. So there are the number of issues arises, and those who thinks that they can file PIL, they should file. But as a law students, multiple law students have filed PIL in various law colleges. As if you go through the news and you find students from various colleges have filed PIL on for the particular issues arises in the state or city or in the law, in the anything. So that's why I have thought to teach you, and even earlier classes I have taught the same things. Ayush Taneja is joining too late. I'm not going to accept. Okay, so whenever we start drafting any PIL, we have to understand what will be the topic, on which topic we have to start preparing draft. So the best is to determine the topic, and as I determined, as we can start drafting over Citizenship Amendment Act, that is CAA. While drafting, we will be getting know what exactly Citizenship Amendment Acts are, what are the loopholes, why government are enforcing, why public are opposing, why PILs, large number of PIL, more than 236 PILs are filed before Supreme Court, while matter is still sub judice. So these things will be come under the process when we start drafting this PIL. And for that, all of you, maybe today around 40, 42, 41 students have joined. All 41 students should go through the content of Citizenship Amendment Acts through various sources and try to learn what exactly Citizenship Amendment Acts are. And since we have 20 minutes more, on 8 p.m. I will be closing this session. So I find still I have 20 minutes more. Within 20 minutes, I can teach you basis of PIL. If you have a notebook and pen, please note down few things for drafting. What points exactly we will be adding in PIL, and how we will go. How will we starting all these. So any of the PIL when we start prepare, if we go through the content, have legal research, and we are determined that will include all these facts in our PIL. So suppose uh, we have content of 10 pages, 20 pages. We include everything, all about the historical perspective, all about the current positions in PIL, facts, and then once we prepare all these things, suppose we have 20 pages of facts. Now we have to inform the court, and we have to orate before the court. So we prepare synopsis. In synopsis, we include everything: who is the petitioner, what exactly facts are there in the PIL, and what exactly points we are challenging. So these things and what our intention are to file this PIL. So all these things are included in synopsis. Clear? So for that, you must note down the topic, that is Citizenship Amendment Act. There are two things, CAA and NRC, but we are not challenging NRC, so we will not be preparing draft for NRC. We are just preparing draft for CAA, Citizenship Amendment Act. So there you must be having knowledge since 1950, 1947 to till now, what exactly citizenship amendments are, how this act was uh, constituted, how this act was enforced, and how this act was amended. Everything you should go through the uh, books and various sources, and everything you should acknowledge. So note down in your pen, I mean notebook, in 1950, Constitution adopted the criteria of citizenship, which includes Article 5 to 11, which deals about citizenship of India. As you know, if you go through the history of India and division of India and Pakistan, we get to know that the division is although political, but there was the basis. Religion was one of the factor, and when the citizenship criteria was enacted or introduced before the assembly at that time, there are various leaders who propagated and supported the idea of creating citizenship criteria on the basis of religion. But there are some leaders who were opposing this, and they said, since India is a secular, although at that time secular word was not inserted, but although they were propagating about secularism and talked about that any of the law cannot be created on the basis of religion, so no citizenship criteria would be there on the basis of religion. And these kinds of discussion took place in the assembly in 1950. Okay, if we go through various resources like Assembly of India
Sir,
debate, yes,
do you mind repeating the articles 5 to 11? Is what you said.
yes, yes, Article 5 to Article 11, 5, 6,
Thank you,
7,
sir.
8, 9, 10, 11. So at that time, if there's a debate, archival. If we go through the Assembly of Debates, Indian Debates Proceedings, Volume 11, held on 12th August 1949. And if you go through about the creation of citizenship criteria, what you find exactly is that it states that we are plied to the principles of secular state. We may make a distinction between people who voluntarily and deliberately chosen another country as their home and those who want to retain their connection with this country, but we cannot, on any racial or religious or other grounds, make a distinction between one kind of persons and another, or on sect of persons and another sect of persons, having regard to commitments and the formulation of our policy on various occasions. So this was the statement held in assembly, and the source is Assembly of India debates proceedings. You can, if you are able to note down, you can do so. Otherwise, the same will be recorded. The video is being recorded, so that will be uploaded. You can go through again and note down these things because these will be included in drafting. All of you have, those who are attendees, they have to prepare their own draft separately in Microsoft Word file, and time to time I will be checking it. So whatever I'm going to teach you, you just note down everything. If you are able to note down, otherwise you can go through the videos. So this statement, including the constitution adopted the criteria of citizenship and included Article 5 to 11, which deals with Indian citizenship, and also leaders uh, uh, rejected the criteria of religion based. And also, Sir Aladi Krishnaswamy Layar, one of the uh, district lawyer leader, discussed Article 5 in the Constitution Assembly, and then the statement was as follows. In 1955, Citizenship Act 1955 was enacted. The Citizenship Act 1955 was enacted in 1955. And then in 1987, that pursuant of the powers conferred by the Constitution, Parliament enacted the Constitution, Citizenship Act 1955. Since 1955, Citizenship Act is there. So under this existing law, prior to enactment of Citizenship Act, Citizenship Amendment Act, Any person who was born in India till 1987 is an Indian citizen without any further addition or modification. Is it clear? In 1987, prior to enforcement of this law, those who are residing in India, they will be known as Indian citizens till 1987. And then in 1987, India followed the criteria of citizenship by birth. The criterion is narrowed down for the persons born in India between 1987 to 2003. A person can also be registered as an Indian citizen. A person qualifies if, among other grounds, she is of Indian origin and has been residing in India or outside undivided India, is married to an Indian citizen, or if a minor child of Indian citizens. So these are the criteria made in 1987, in which between 1987 to 2003 was the period where the criteria was narrowed down, where granting citizenship was not there, and even seeking citizenship was difficult. A person can also apply for citizenship through naturalization following the procedures laid down in the Act and rules. So, here what we understand is in 1950 they inserted articles 5 to 11 which only talk about how citizenship will be granted, who will be eligible, who will be granting, what will be the criteria. So these are the mentioned in Article 5 to 11. And separately in 1955, Citizenship Act was enacted, and separately it talks about how citizenship can be enforced, how citizenship can be granted, what will be the criteria. So everything was there. And in 1987, it was made clear that, and one of the amendment took place in 1987, and it talked that those who are existing in India, residing in India, can be granted citizenship without any documentations. But those who are applying for citizenship or challenging their citizenship after 1987, they will have to go through the criteria. The criteria was as follows: that one of the parents belongs to India, where the child is born in India. So these are the criteria. And as I said, 1987 to 2003 was the time where the criterion was narrowed down. It means that granting citizenship was not easy. Seeking citizenship through the criteria even was not easy. Now let me talk about 2004. In 2004, Citizenship Act was amended by introducing illegal migrant. In 2004, illegal migrant means what happened in India. Beside the territory, large number of population resides, and nobody knows who are coming from different country or by beyond the border. Those who are residing and jumping the border and residing in India as an Indian citizen, they don't have documents, they don't have citizenship to prove. So they are known as illegal migrant. They are the migrants. If all also they are not getting their job employment, or the government is torturing them, and also if they are being harassed by the government, so they come to India, they reside in India. They are known as migrant. Like if we talk about in Rohingya, the government started killing them. There were the mass killings. So most of them fled from their country and sought asylum in Bangladesh, in India too, and also some of them migrated illegally. So there was no such word inserted in Citizenship Act. They have been they are verbally known as illegal migrant. So in 2004, this illegal migrant word was inserted and amendment took place. Uh, and it says that the illegal migrant was defined as that someone who enters or stay in India without legal authorization is known as illegal migrant. And it was mainly to curb those Bangladeshi residing in India and in Northeast or in Bengal area, mostly because of their quantity of the people residing in India. So this illegal migrant was inserted because some of them was there residing as Indian and had voter ID cards and also maybe Aadhaar cards. So it was uncertain. It was difficult to recognize them. Thus, after the amendment, any child, yes,
Just to clarify, before 2004, anybody who migrated from their country or like escaped from their country into India, they were considered legal if they were living without any documents. But after 2004, they became illegal migrants. Is that correct?
no, actually, they were not even legal before 2004, but there was no such defined criteria, those who are residing. Because, as you say, uh, I'm not a member of certain club, okay? It doesn't mean I cannot go to the club or I cannot be a member of that club, right? If I am a member of club, it means I may be granted certain rights and certain facilities. So the criteria for the members are defined, but those who are not member, what they can't enjoy is not defined. Similarly, in this matter, before 2004, illegal migrant word was not inserted, and if that is not inserted, so it was ascertained to define tell them as they are the illegal migrant. But even though they are not illegal migrant, we cannot, I mean, even though the illegal migrant was not there, we cannot say they are the illegal migrant. Clear?
Okay, sir.
So what I was saying, the amendment that the amendment of any child before 2004 onward to even one parent who is an illegal migrant would be disqualified from citizenship by birth. Illegal migrants were also disqualified from the other routes to the citizenship. So these were the things till 2004, and after 2004, criteria was made, illegal migrant definition was included, and they started to recognizing or curving them. But in 2015, September 2015 was there when government exempted exempted non-Muslim illegal migrant. Okay, so what happens? There were the Bangladeshi, there were the Pakistani, there were the Afghanistani, and so on. Other country members were there residing in India. Muslims, non-Muslims, and everyone with different caste, creed, language, birth. So all of them were residing in India, and they were illegal migrant. But in 2015, government exempted non-Muslim illegal migrant from three countries from operation of Foreigners Act. They separate act called for the Foreigners Act. The Foreigners Act is apply upon those who are the illegal migrants, those who are the migrants those who are residing in some other country and coming back to India and residing. So this act mostly applies to them, Foreigners Act. What had happened in 2015, government exempted non-Muslim illegal migrants from three countries from the operation of Foreigners Act through an executive order. So who gave these executive orders? Mostly government department or government ministry, Ministry of Home Affairs, Ministry of External Affairs. These are the bodies are responsible for the Indian foreigner issues. Ministry of Home Affairs had directed an issue executive order and says that although they are the illegal migrants, but only Muslim, non-Muslim, I mean non-Muslim are exempted from illegal migrants. Means they are neither legal, they are neither legal, they are not illegal. It means both. It is up to the government. If the government want, they can declare them as illegal. If the government want, they can declare them legal. But they will not fall under this provision of illegal migrant. So government exempted non-Muslim from three countries. This provided immunity to the class of migrants from any adverse action or any state due to illegal entry or stay. It, because of this order, those who are illegally residing, just because they are residing from these countries, because they belongs to certain religion, they can't face adverse action by the government, and it boosts their immunity to work further. So in 2015, government executive order that they will be the certain religious person will be exempted, and those were Hindu, Sikh, Buddhist, Jain, Parsi, and Christian minorities. They are exempted. Okay, they are exempted from three countries. In which three countries? Bangladesh, uh, Afghanistan, and Pakistan. So that's how government direct through this directive orders uh, that is exempted the three category of people residing from three different countries, and which includes six religious person: uh, Hindu, Sikh, Buddhist, Jain, Parsi, and Christian minority. Okay, so why Muslim were excluded? That was the first question. And in 2018, some Ministry of Home Affairs, Home Ministry also issued another directive, and which accelerated the process for non-Muslim legal migrants from three countries to get citizenship. It means 2018 was there when government had started granting citizenship to the non-Muslims from three countries, which was also based on religion. And then, as you know, as you are aware of the protest in 2019, in 2019, Citizenship Amendment Act 2019 was passed. There were Citizenship Act in 1955, and then there was Citizenship Amendment Act 1987, then again amendment 2004, then our executive orders, various orders between 2015 to 2019. And separately, in 2019, Citizenship Amendment Act was passed by both the houses, and it was notified to the president. And also, the Citizenship Amendment Act removes disqualifications based on illegal migrant for minority communities, specifically Hindus, Sikh, Buddhist, Jain, Parsis, and Christian. Those who belongs to Afghanistan, Bangladesh, and Pakistan. These groups would not be considered as illegal migrant, thus allowing them and their descendants to be Indian citizens or apply for Indian citizenship. And also, this amendment shortens the minimum period of residence in India for them. Instead of 11 years, now if they are residing only 5 years, they will be qualified for citizenship. Okay. And thus, in effect, neutralization, specifically for non-Muslim migrants from these three neighboring countries, the amendment seeks to make two changes. It removes their and their descendants disqualification from citizenships and accelerates citizenship by neutralization. Is it clear? So, this is the actual matter I have described in short. You can go through your own and find what exactly issues are there, what history are there, why Muslims were excluded. Though although government generally is public says that they excluded Muslims because Muslims are residing already in Pakistan, Afghanistan, Bangladesh, and minorities. Those minorities who are residing in these three countries are in minority, not in majority, and minorities are always persecuted. So the government took defense of persecution. So not only Hindu but Christian, Parsi, Jain, Sikh, those who are residing in these countries, they are being persecuted. They are not being availed their rights. They are curtailed from various opportunities. So that's why they are desperate to come to India. So we are granting them. We are availing them their human rights on. So they took defense of persecution. And why Muslims were against of it? Because Muslims says that firstly they are curtailing Muslims, they are excluding Muslims from these laws, I mean these criterias. And Article 15 talks about no laws can be enforced made on the basis of religion. So it is violating the principle of equality. Article 14, it also violates the Article 15 talks about religion. It also violates various other articles. And further, not only that, why, they are the countries where Muslims are in minority and facing the same persecution. So they talk about even China has a Muslim minority. Muslims are facing persecution there, and so on. So it is should not based on religion. It should based on the the human rights. It should based on the criteria, and it should be on based on equal equality. So these were the challenges, and for that all those have filed PIL before Supreme Court. Kapil Sibal is the has collabed all those PIL, and you can, if you follow up these dates of CA proceedings before Supreme Court, you will get to know more about it. So today I have just elaborated everything. In fact, I have told you series wise, date wise, everything, and it is known as list of events. That is also included in PIL draft. And tomorrow, I mean, the next class, your duty is to learn about it and prepare a summary. In next class, till Friday, you have to provide us synopsis of this. What exactly would be there in synopsis? So I tell you first to uh, open. You have to open your MS Microsoft Word file. There in the middle, you have to type synopsis, and below that, you have to tell three things. Firstly, you have to, since you are filing PIL, and locus standi should be there, you have to tell the court why you are filing PIL. You are not a grip party because you are talking about large number of people. So court will ask you, what's your concern? Why are you filing PIL? Just to get public name, fame? And if so, then your PIL is rejected. If you wish to get your name in media, you wish to draw attention of the media, you would get your name printed in newspapers, and so for such reason you are filing PIL, then your PIL is rejected. So that's why we have to ensure these things while telling in the PIL. And when we start writing synopsis, the very first what we write is note down. We have to write first synopsis, and below that we write the petitioner is a public interest litigant, and the petitioner is a, and whatever the petitioner position is in society, whatever that is, layman is a president of the any NGO or any other thing. So that's how you can write that the petitioner is a president of so and so NGO, that the petitioner is apprehensive that CAA process will exclude millions of poor, vulnerable people from Indian citizenship, particularly the post partition refugees, minorities, and undocumented migrants, rendering them stateless. The petitioner is involved in various public, social, social works, and is the president of a youth organization called whatever the organization, whatever that is. We just have to emphasize that the petitioner is already indulged in public welfare. So that's why public petitioner is interested to file this PIL, which undertakes socially relevant and welfare activities in India. The petitioner is a public interest litigant and is filing the present writ petition against the respondent seeking relief of declaration that the CAA 2019 and other executive orders are the against of constitution and are void. These things will be included in synopsis. And then next point you have to add that the petitioner is seeking enforcement of fundamental rights under Article 14 and Article 21 and seeks to assess the following. What? First, validity of Section 14A of Citizenship Act 1955. Second, validity of Section 18, Clause 3 of Citizenship Act 1955. And then we have to talk about notifications. There are the 5 to 6 notifications issued by the executive body of Ministry of Home Affairs. Okay, and then you have to explain these things. What? Validity of Section 14A. Why you are challenging validity of Section 14A? You have to explain about it. Then you have to explain validity of Section 18 of the Indian Citizenship Act. Why are you challenging? You have to explain it. And then these 6 notifications. Why these 6 notifications are ultra virus? Why these 6 notifications are against the constitution? Why and how these are breaking laws? So you have to explain all these things in synopsis only. Understood? I repeat again that you have to prepare synopsis after this class. You need to go through CAA, about the CAA, its history and everything. Then you need to prepare a synopsis for the PIL, and then in synopsis you have to explain about the petitioner, and then you have to tell why petitioner is filing this petition, and then you have to talk about by filing this what exactly issues are. Like I said, that the uh, petitioner is apprehensive that CAA process will exclude millions of vulnerable people from Indian citizenship, particularly the post-partition refugees, minorities, and undocumented migrants, rendering them stateless. So that's how you can mention, and then you can say that the petitioner is seeking enforcement of fundamental rights under Article 14 and 21 and seeking as else the following. And then what followings are? First point is validity of Section 14A of the Citizenship Act 1955, validity of Section 18, Clause 3 of Indian Citizenship Act, and then similarly you have to challenge all these 5 to 6 notifications. What I will do, I will assist you in preparing synopsis by providing you all these challenging points from validity of just now I'm going to provide you all these things. You can go through the, you can download these notifications. You can go through Citizenship Act section 14A, section 18 clause 3, and then you can prepare it accordingly. Okay, so I have just sent it to you, all these points, and you need to go through all these points and prepare synopsis only. And also remember, I want synopsis to prepare within at least 6 to 7 pages, 5 to 7 pages. Minimum 5 pages should be there in synopsis. Okay, you have to explain all these things, not long but short, because you have to prepare a long facts as well. In facts, you have to explain everything one by one, so you need to have some matters for the facts as well. The overall PIL pages would be around 30 to 40 pages minimum. 30 to 40 pages of the PIL would be. So for that you must be having more and more content, and 5 pages are covering, five minimum 5 pages are covering for synopsis only. So, by starting with the petitioner and by quoting about the issues and then challenging the 6 points, 6 issues include notifications, and then you have to explain each thing. Is it clear? On Friday, everyone should provide synopsis email in my email, and I will be checking live on Saturday. Those who are unable to submit till Friday, or you think that you cannot submit till Friday, they should prepare early. But do not say that just because of my personal engagement, just because I was traveling, or just because I was hanged out, or whatever the various reasons are there for the students. I will not be considering any of the reason. So you have Sunday, Monday, Tuesday, Wednesday, Thursday, even Friday. Till Friday, till 5 p.m. Prepare only synopsis containing in 5 pages and email me. And also, student leader should be acknowledged through the group that you have emailed. Student leader has a duty to note down their submission, okay, that these students have submitted in Excel sheet, those who are the attendees. Is it clear?
Yes, sir.
Those who faces issues in understanding of any of the particular things, they can go through the videos and student it, and further student leaders are there, they will be explaining whole things in case any of you face any issue. And in framing synopsis, preparing synopsis, you take support of the video. Whatever I have told you, just you, even if those materials if you mention in that, but you need to challenge all those 6 points too. For that you need to explain yourself. I haven't explained in this video. It is your task to learn about it and explain it and prepare. At least minimum 5 pages are required for synopsis. And also remember that uh, uh, word size should be 14, or font style should be Arial, and it should be justified, and also give proper margin, And on only and one more last thing is provide me in PDF file, not my Word file. Because if you send Word file, the the style, the format is distorted generally. So provide me in PDF file through email at advocatespedia@gmail.com till 5 p.m. on Friday. Okay, thank you so much. And Aditi, you may share a list of students' name to me, those who are the attendees. Also prepare separate list for you and remember that for the next task.
Okay, sir.
Okay, have a good time. All the best. All of you may leave.
Thank you, sir.
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 Excuse me, sir.
Yes.
Sir, I took attendance at 7:20.
Mm-hmm.
So there were around 45 students.
Mm-hmm.
So is that okay?
But yeah, but what I could see at that time is only 41 students was there.
Yeah.
So do
Sir,
one
I
thing.
have the names of the people, but it is of 40 students who were there before 5 minutes.
Hmm.
So what list should I provide you then?
Okay, you can provide the list, and also once the video is uploaded, you can go through the video and find out whether 41 or 45.
So like, do I need to say any time? Because in the whole procedure, people were leaving and coming.
Yeah.
There was nothing. Hmm.
Hmm. Okay, consider whatever proper fit for as you think, because I was not going through the attendees' name. So if they
Yes.
have joined, at least if they have attended in the mid time, due to network issues, some of the intern has to leave or just it gets network error. So we'll consider both the issues, but
So
maximum.
should I provide you a list of 45 students then? The
Yeah,
total number of students.
yeah.
Okay. Thank you.
Also
Just
publish in the group too. Okay.
what, sir?
Also publish the list in the group.
Okay, okay.
Yeah.
Okay, sir. Thank you.